The John Magnier and Barne Estate High Court or Commercial Court row court case is generating a lot of interest, and obviously Irish people have a great interest in land, in property, and they have an interest, I suppose, in John Magnier as well, and the whole Coolmore operation, and the fact that he's a billionaire and he's given evidence that he's a billionaire. So there's a lot of interest in the case itself. But in this video I want to just touch upon the legal aspect of it and what the law says in relation to contracts for the sale of land. So the contract or the law surrounding the sale of land goes back to the Statute of Frauds in 1695. 1695, the Statute of Frauds, Section 2, provides that in order to be enforceable, the contract for the sale of land must be in writing, or there must be a note or memorandum of the agreement. So that's the starting point. If this section, that is Section 2 of the Statute of Frauds Act 1695, is not complied with, the agreement, while valid, is unenforceable. The memorandum or note then, what is it supposed to contain? It's supposed to contain four things. 1, the parties, who's involved. 2, the price. 3, the property. And 4, the particulars, in other words, the statement, a statement of the material important terms of the agreement. So the 4 P's must be evidenced in writing in a memorandum or note. That goes back to 1695, the Statute of Frauds, Section 2. That was repealed. The Statute of Frauds 1695 was repealed by the Land and Conveyancing Law Reform Act of 2009. That's what's on the statute books now. And what does it say about contracts and the enforceability of contracts and so forth? I'm having a look at that there now, and Section 51 of this Act says that subject to subsection 2, no action shall be brought to enforce any contract for the sale or other disposition of land unless the agreement on which such action is brought or some memorandum or note of it is in writing and signed by the person against whom the action is brought or that person's authorised agent. So there must be a memorandum or note signed by the vendor or by the vendor's agent. That is subject, and that's basically a replication, as it were, or a reaffirmation of Section 2 of the Statute of Frauds Act 1695. However, there is a rider, or there is a proviso, because subsection 2 of this Act, of this particular section, Section 51 of the Land and Conveyancing Law Reform Act of 2009, which makes the provision, repeats the provision for evidence in writing being necessary. Subsection 2 says, subsection 1 does not affect the law relating to part performance or other equitable doctrines. So there's an equitable doctrine of part performance where if a person enters into a contract and claims to have performed their part of it or have performed what they were supposed to do, then they have equitable relief. In other words, that there's an equitable doctrine of part performance which allows them to enforce the contract. Perhaps that is the basis on which Mr. Magnier is bringing these proceedings, or perhaps he has evidence in writing, a memorandum or note containing the 4 P's. That remains to be seen. We'll see as the evidence unfolds. And then that Section 51 of the new Act, the 2009 Act, says, just by way of information, subsection 3 says that for the avoidance of doubt, but subject to an express provision in the contract to the contrary, payment of a deposit in money or money's worth is not necessary for an enforceable contract. So that's the situation. It will be interesting to see how it pans out. It'll be interesting to see what evidence there is in writing, what evidence there is of a note or memorandum containing the 4 P's, that is the parties, the price, the property and the particulars. Let's wait and see. Perhaps Mr. Magnier is relying on this equitable doctrine of part performance. Perhaps it, as I say, remains to be seen. But from a legal perspective, from a law student's perspective or a law professional's perspective, it'll be interesting to see what the outcome is. I have a firm view as to what might happen, but my firm view was based on only 1 or 2 days evidence. And remember, in a 3-mile chase, the first furlong, you'd be a brave man or woman to pick a winner after the first furlong of a 3-mile chase. Likewise, in this case, if it's expected to last 13 days, which is the case, well then you'd be a brave or foolish person to be making sound or confident predictions based on the evidence of 1 or 2 days. So it remains to be seen. The evidence, like any case, is absolutely key. Hope you liked the video. Hit the thumbs up button down below if you do. Thank you very much.